Hi, I'm John Farrow with the Farrow Law Firm, an estate planning attorney here to help you navigate the tricky world of estate planning. In this video, we're going to cover 5 things you should never include in your will. These are common mistakes that can create confusion, delays, or even legal disputes for your loved ones. Stick around because I'll also share the right way to handle these situations so your estate plan works exactly the way you intend. Let's dive into one of the biggest mistakes people make when writing their will, including funeral instructions. It might seem like the perfect place to outline whether you want to be buried, cremated, or have a specific type of service, but here's the issue: timing. A will is often read days or even weeks after someone passes away, long after funeral arrangements have been made. By that time, your loved ones may have made decisions that don't reflect your wishes simply because they didn't know what you wanted. Imagine this: a person passes away and their family assumes they'd want a traditional burial. They make all the arrangements, pay for the burial plot, and hold a service. Weeks later, the will is read and it states the person wanted to be cremated. Now, the family faces guilt and frustration. So what should you do instead? Here are 3 simple and effective ways to make sure your funeral wishes are clear and honored. Number 1, communicate your wishes directly. The easiest way is to have a conversation with your loved ones. Sit down with the people you trust, your spouse, children, or close friends, and tell them exactly what you'd like. Here's an example. Do you want a burial, cremation, or something more unique like a green burial or even having your ashes scattered in a special place? Talking about it now helps eliminate confusion later. Number 2, create a separate document. If you want to formalize your wishes, you can write a document specifically for funeral and burial instructions. Here's a pro tip. Keep this document somewhere easy to find, like in a folder with other estate planning documents, and let your loved ones know it exists. You can even include it in your estate planning binder if you have one. Step 3, designate a decision maker in advance. In many states, you can legally appoint someone to handle your funeral arrangements. This person, often called an agent for disposition of remains, will have the authority to make decisions based on your instructions. Why is this helpful? It avoids conflicts between family members who might have different opinions. For example, if your children can't agree on burial versus cremation, your designated agent can step in and make the decision without debate. Here are the 3 steps for handling funeral instructions the right way. Communicate your wishes to loved ones, create a written document outlining your preferences, and legally appoint someone to handle funeral arrangements. One more thing to consider: prepaid funeral plans. Some people choose to pay for their funeral expenses in advance to reduce the financial burden on their family. While this can be a great option, it's still important to communicate your preferences so your family knows you've already made those arrangements. At the end of the day, your funeral wishes are deeply personal. By planning ahead and handling them outside of your will, you can ensure your loved ones honor your choices without the added stress or confusion. Now that we've covered funeral instructions, let's move to another critical decision that often gets misplaced in a will: organ donation. Many people want to save lives by becoming organ donors, which is an incredible gift. But just like funeral instructions, including organ donation preferences in your will is problematic because of timing. When it comes to organ donation, every second matters. Decisions about whether your organs can be donated are made almost immediately after death, long before your will is even read. If your family or healthcare providers don't know your wishes right away, that opportunity could be lost. Picture this: a person passes away and has healthy organs that could save up to 8 lives, but because no one knew what they wanted to be a donor, or they included in their will, it's too late to act by the time the will is reviewed. Lives could have been saved or lost. So how do you make sure your organ donation wishes are clear and acted upon in time? Here are 3 simple steps. Step 1, register as an organ donor. In most states, registering as an organ donor is as simple as checking a box when you renew your driver's license or ID. In some states, you can also sign up online through your local organ donor registry. Here's a pro tip. Take a moment to confirm your organ donation status the next time you renew your license. If you've already registered, look for the little red heart or organ donor symbol on your license. It's that easy. Step 2, communicate with loved ones. Even if you've registered, it's crucial to have a conversation with your family. Healthcare providers often consult with your next of kin about organ donation, even if you're registered. For example, tell your spouse, children, or other close relatives why being an organ donor is important to you. If they understand your wishes, they're far more likely to support them when the time comes. Step 3, include organ donation preferences in your medical directive. A medical directive, also called an advance directive or healthcare power of attorney, is a legal document where you can outline your organ donation preferences. Why is this helpful? It ensures that both your doctors and your loved ones know your wishes, and it's legally binding in most states. This can be especially important if there's any disagreement among family members. Here are the 3 steps to ensure your organ donation wishes are respected. Register as an organ donor through your state's registry or DMV, talk to your loved ones about your decision, and include your wishes in a medical directive or advance directive. By taking these steps, you're not only ensuring your wishes are respected, but you're also giving the gift of life to others. It's one of the most selfless decisions you can make. In fact, one organ donor can save up to 8 lives and improve the quality of life for dozens more through tissue donation. Imagine the impact your decision could have, not just on the recipients, but also on their families and communities. So to recap, organ donation is a beautiful gift, but your will is not the place to include it. Register through your state, talk to your family, and document it in your medical directive. By planning ahead, you ensure that your legacy includes saving lives. Now let's talk about a mistake that could significantly impact your loved ones financially, including retirement accounts like IRAs and 401ks in your will. Many people don't realize that retirement accounts don't follow the instructions in your will. Instead, they are governed by beneficiary designations, which are filled out when you set up the account. These designations override anything written in your will. So what does this mean? Even if your will states that your retirement account should go to a specific person, the beneficiary listed on the account will get the money. This can lead to serious problems if your beneficiary designations are outdated or incorrect. Imagine this. Years ago, you set up a 401k at your first job and listed your sibling as the beneficiary. Fast forward 20 years. You're married with kids, but you never updated the beneficiary form. You pass away, and even though your will says your retirement account should go to your spouse, the sibling listed on the form gets the money. This kind of situation happens more often than you'd think, and it's completely avoidable. So how can you make sure your retirement accounts are handled properly? Here are 4 essential steps to everything on track. Step 1. Review your beneficiary designations regularly. Take the time to review and update the beneficiaries on your retirement accounts at least every 3 to 5 years, or after any major life event such as marriage, divorce, the birth of a child, or the death of a loved one. For example, you might have named your parents as the beneficiaries when you first opened the account, but if your parents have since passed away, failing to update your beneficiary designations could cause delays and unnecessary costs for your heirs. Here's a pro tip. Set a reminder to review your beneficiary designations every 3 to 5 years. Step 2. Coordinate with your estate plan. Make sure your beneficiary designations align with your overall estate plan. If you've worked with an attorney to create a will or trust, double check that the people listed on your retirement accounts match your intentions. As an example, if your estate plan includes a trust to manage assets for minor children, you can name the trust as the contingent beneficiary. This ensures the funds are distributed according to your instructions, rather than being given directly to young or inexperienced beneficiaries. Step 3. Avoid naming your estate as the beneficiary. One common mistake is naming your estate as the beneficiary of your retirement accounts. While this might seem like a simple solution, it can create unnecessary tax consequences and delays. Here's why. Naming your estate as the beneficiary means the account must go through probate, which can take months or even years to resolve. Retirement accounts left to an estate often lose the tax benefits of stretching withdrawals over time, resulting in a larger tax bill for your heirs. Here's what to do instead. Always name individual beneficiaries or trusts that are specifically designed to handle retirement assets. This preserves the account's tax advantages and avoids the probate process. Step 4. Understand the Secure Act's impact. The Secure Act, which went into effect in 2020, significantly changed how inherited retirement accounts are handled. Under the new rules, most beneficiaries are required to withdraw the full balance of an inherited IRA or 401k within 10 years. Why does this matter? If you're leaving a large retirement account to someone, they may face a hefty tax bill if they have to withdraw the funds in a short time. Here's the solution. Work with an estate planning attorney to create a strategy for minimizing the tax burden on your heirs. For example, a trust can be structured to control how and when beneficiaries receive distributions, helping them manage the tax impact. By following these steps, you can ensure your retirement accounts are handled properly and avoid unintended consequences. Let's recap. Review and update your beneficiary designations regularly. Coordinate your retirement accounts with your estate plan. Avoid naming your estate as the beneficiary, and plan for the tax implications of the Secure Act. Retirement accounts often represent a significant portion of your wealth, so it's worth taking the time to get this right. Your loved ones will thank you for it. Next, we'll discuss assets held in a trust and why you shouldn't include them in your will. It's a common mistake, including assets that are already in a trust in your will. This one can be a little tricky because people often don't realize how trusts and wills interact. Here's the key point to remember. Any asset that's held in a trust is controlled by the trust, not your will. Your will only governs assets that are in your name alone at the time of your death. If you've gone through the effort of setting up a living trust, that trust essentially replaces the role of the will for the assets it holds. Writing conflicting instructions for those assets in your will can create unnecessary confusion and even legal disputes. Let's say you've transferred your home and investment account into a living trust. The trust specifies that these assets should be divided equally among your 3 children when you pass away. But in your will, you mistakenly write that your home should go to just 1 child. This creates a major problem. The trust instructions take priority, so the home is divided among all 3 children. The 1 child you intended to receive the home may feel slighted, and disputes could arise, even though you thought you were being clear in your will. So how can you avoid this kind of conflict? Let's break it down into 3 key steps. Step 1, understanding what a trust does. A trust is a legal entity that holds assets and specifies how they should be managed and distributed. Once an asset is placed in the trust, it is no longer part of your personal estate. It's owned by the trust. Why does this matter? Your trust document, not your will, governs what happens to those assets. Including trust-held assets in your will doesn't change the instructions already outlined in the trust. It only creates unnecessary confusion. For example, if your trust states that your stock portfolio should go to your niece, but your will says that it should go to your nephew, the trust instructions will win every time. Step 2, coordinate your trust and will. Think of your trust and your will as 2 parts of the same plan. While the trust governs assets placed in it, the will acts as a safety net for anything left out. Here's a pro tip. Work with your estate planning attorney to ensure your trust and will are perfectly aligned. If you update one, you should review the other to avoid conflicts. Step 3, keep your trust funded. One of the biggest mistakes people make with trusts is forgetting to fund them. A trust only works if the assets are actually transferred into it. How do you fund a trust? For real estate, you need to retitle the property in the name of the trust. For financial accounts, notify your bank or brokerage company and update the account ownership to the trust. For personal property, some items can be transferred through a general assignment document. If assets are left out of your trust, they'll still need to go through probate, even if you have a trust in place. This defeats the whole purpose of creating the trust in the first place. As an example, imagine you create a trust and list your home in it, but you forget to officially transfer the title to the trust. When you pass away, the home is still in your name and the will have to go through probate, even though the trust was meant to avoid this. Here are the 3 steps to properly manage trust assets. Understand that trust instructions take priority over your will. Align your trust and will with the help of an attorney, and keep your trust fully funded to avoid probate. Here's another pro tip. If you've created a trust, make sure your family knows it exists and where to find it. One of the biggest challenges we see is when loved ones can't locate important documents. A well-organized estate plan is a gift to your family that saves time, money, and stress. Before we move on, let's quickly clear up a few common misconceptions about trusts. Number 1, doesn't everything automatically go into the trust? Unfortunately, no. Just creating a trust doesn't mean your assets are automatically transferred. Each asset must be individually retitled or assigned to the trust. Number 2, can't my will change the trust instructions? No. Once an asset is in the trust document controls it. Your will has no power over those assets. Here's what you need to know. Trusts govern assets placed in them. Wills govern assets left in your name and keep your trust funded and aligned with your will. By properly managing your trust and will, you can ensure that your estate plan works exactly as you intended, with no confusion or disputes. Next, let's talk about another mistake people make, including life insurance and annuities in their will. Many people think that listing these assets in their will is the right way to ensure they're passed down to the right person. But here's the truth. Life insurance policies and annuities are governed by beneficiary designations, not your will. This means the person listed as the beneficiary on the policy or contract will receive the proceeds, regardless of what your will says. Let's say you bought a life insurance policy 20 years ago and listed your sibling as the beneficiary at the time. Over the years, your circumstances have changed. You got married, had children, and decided you wanted your spouse to inherit the policy's $500,000 death benefit. But here's the catch. You forgot to update the beneficiary form. Even though your will clearly states that the policy should go to your spouse, the insurance company will pay the $500,000 to your sibling because they're listed as the beneficiary. It's that simple and that frustrating. So how can you avoid costly mistakes like this? Let's break it down into 3 simple steps. Step 1, regularly review and update beneficiary designations. Just like with retirement accounts, it's crucial to review your life insurance and annuity beneficiary designations regularly, especially after major life events like marriage, divorce, or the birth of a child. Why is this important? The beneficiary listed on the policy takes precedence over anything written in your will. So keeping these designations up to date ensures your wishes are followed. For example, a client of mine listed their parents as beneficiaries on a life insurance policy they bought in their 20s. Decades later, when they passed away, the parents, now elderly and financially secure, received the payout, while the client's spouse and children, who depended on that money, got nothing. All of this could have been avoided by updating the beneficiary form. Here's a pro tip. Review your beneficiary designations every 3 to 5 years or after major life changes. Step 2, name a contingent beneficiary. A contingent beneficiary is someone who receives the proceeds if the primary beneficiary isn't alive or cannot accept the inheritance. Why does this matter? Without a contingent beneficiary, the policy's death benefit could end up in your estate if the primary beneficiary is no longer living. This forces the proceeds to go through probate, which adds delays, legal fees, and potentially higher taxes. Here's an example. If you name your spouse as the primary beneficiary and your child as the contingent beneficiary, the death benefit will go to your child if your spouse passes away before you do. This simple step ensures the money goes where you want it, no matter what. Step 3, use a trust for complex situations. If your situation is more complicated, such as having minor children, special needs beneficiaries, or concerns about financial responsibility, consider naming a trust as the beneficiary of your life insurance policy or annuity. Why is this a good idea? A trust allows you to control how and when the money is distributed. For example, minor children can't legally inherit money directly. A trust can hold the funds and distribute them when the child reaches a certain age, such as 25 or 30. For beneficiaries with special needs, a properly structured trust can ensure they receive support without jeopardizing government benefits. If you're worried about a beneficiary spending the money irresponsibly, the trust can distribute the funds in smaller installments rather than as a lump sum. Before we move on, let's clear up a couple of misconceptions about life insurance and annuities. Doesn't my will control everything? No. Life insurance and annuities are contract-based assets. These beneficiary designations on the policy determines who receives the money, not the instructions in your will. Do I need to name my estate as the beneficiary? In most cases, no. Naming your estate as the beneficiary forces the proceeds to go through probate, which creates unnecessary delays and may reduce the amount your loved ones receive due to legal and administrative costs. By properly managing your life insurance and annuity beneficiary designations, you can save your loved ones time, money, and unnecessary headaches. Let's recap the key points. Regularly review and update your beneficiary designations. Always name a contingent beneficiary and consider using a trust for minor children, special needs beneficiaries, or complex situations. And there you have it. 5 things you should never include in your will. Let's quickly recap. Number 1, funeral instructions. Number 2, organ donation. Number 3, retirement accounts. Number 4, assets in a trust. And number 5, life insurance and annuities. The key takeaway, your will is just one piece of your estate plan, and some things are better handled through other documents or beneficiary designations. If you found this video helpful, hit the like button and share it with someone who's working on their estate plan. And don't forget to subscribe for more tips on protecting your legacy. Got questions? Drop them in the comments or schedule a consultation with us. We're here to help.